With Ramadan on our doorstep, the matter of mosques being open in South Africa during lockdown proceeded today in the Pretoria High Court. Judge Brenda Neukircher is presiding on the matter, which was first heard on Tuesday. Advocate Feroz Boda, senior counsel representing the applicants in the matter, addressed constitutionality concerns as well as explained to the court the current situation at well-known religious sites abroad. The state attorney explained the decision for the lockdown has been a difficult one made by the government, but had to be made to save lives. Here's more from the proceedings earlier today.
In the context of this democracy, then that has, and if your ladyship applies a lesser standard than the ordinary standard, that will have enormous consequences for the civil liberties of all our citizens in this country going forward. Because every day, ministers pass regulations under various statutes, and they do so for all good reasons. There should not be any, your ladyship should be very careful about any submission that says show deference in these circumstances. Your ladyship should apply the ordinary standard justification test that exists in the Constitution. And I stress, why I stress this, my lady, because the opening shot in my learned friends from the state's heads of argument is that we are in a state of emergency. We're not in a state of emergency. In a state of emergency, certain rights, the state has a right to take away certain rights. Certain rights are non-derogable, but we are not in a state of emergency. We are in a state of disaster, and like every other piece of legislation, the National Disaster Act and the regulations promulgated by the minister under that act is subject to ordinary constitutional scrutiny. Now, in the present case, these regulations, as I indicated, effectively make it a criminal offense for any person to travel to or to attend a congregational prayer in any place of worship, including a masjid. The applicants submit that the prohibition is unconstitutional and unjustifiable and offends the right of an individual to practice his or her religion in section 15(1) of the Constitution, the associational right to practice religion in association with others protected by section 31, the rights of freedom of movement and freedom of association. When one looks at the papers, the state did not raise any controversy about three of those rights. The rights to practice one's religion in association with others, that's in section 31. The state readily conceded that the right of freedom of movement and freedom of association has been limited, but the state then seems to, and also the amicus from their papers seem to suggest that the right to practice one's religion in section 15(1) is not impaired. However, it appears from the heads of argument of the state that they now concede that even that right is impaired. The right to practice one's religion is impaired. Because they sought to push this debate away from section 15(1) into section 31, the associational right. So your ladyship can accept that there is a concession that all of these four rights have been infringed, and really the true issue is about justifiability. There's a very important passage in the decision of Christian education, which passage was confirmed also again in the decision of Prince and in other cases. And that is this. Paragraph 35, the Constitutional Court said the following. Accordingly, believers cannot claim an automatic right to be exempted by their beliefs from the laws of the land. A lot of the arguments center around that particular issue, because there is a claim that the applicants seek certain exemptions from the laws of the land. However, there is a very important cautionary note sounded by the Constitutional Court in both these judgments. At the same time, the state should, wherever reasonably possible, seek to avoid putting believers to extremely painful and intensely burdensome choices of either being true to their faith or else respectful of the law. Now, that is why it's very important when analyzing the category of right that the applicants seek to assert in this matter, whether they believe it's compulsory, which attracts a sin, and therefore eschatological consequences in the hereafter, or whether it's simply a voluntary act or a preferred act that they are basing their case on. They are basing their case on the fact that what the state has done is to prohibit what their religion makes compulsory on them. And the state has done and criminalized the performance of that compulsory act so that they find themselves in this exact situation that the Constitutional Court has said a believer should never find himself in. And they specifically say this at page 28 of the founding papers, paragraph 56. They make this very submission to it, and that's not challenged in the answering affidavit. So this is a case where the believers that come before the court are saying to the court, we are in this extremely painful and intensely burdensome position of having to make a choice, because this, they say, is compulsory, or the Arabic word, farad on us. And because it's farad on us, our Lord commands us to do this. If we don't do this, we are going to be sinful. And the state's saying we shouldn't do this, and if we do this, we're going to be prosecuted. That's the position that they find themselves in. The third reason why they say it's farad on them to attend the masjid is based on their personal obligation to attend the masjid. Now, on this part, there's a difference of opinion. I'll readily concede there's a difference of opinion on this part. What they say, and this is from the founding affidavit, page 19, they say that, I think I did alert your ladyship to this when I was arguing urgency, but page 20, there's this hadith of the Prophet Muhammad sallallahu alaihi wasallam about a person coming to him, the Prophet Muhammad sallallahu alaihi wasallam, "O Messenger of God, I have no guide to lead me to the mosque to attend the congregational prayer." He asked the Prophet for permission to pray in his house, and the Prophet permitted him. Then when he turned to leave, the Prophet, peace be upon him, called him and said, "Do you hear the call to prayer?" The blind man said yes. The Prophet then said, "Then respond to it by coming to the mosque." Now there's a difference of opinion on this particular hadith, and whether it, and there's other hadiths that one can draw on, which Uksa relies on. But what my clients believe is that this particular hadith places a farad obligation on any person that can hear the call to prayer. Now, the interpretation of it is, in the Prophet's time, there was no amplification. It's 1400 years ago. So the muaddin would stand and he would shout the prayer out aloud. He wouldn't scream, he would say it in a melodious tone. But the possible people that can actually hear that are very, very limited. And in urban settings where we have these masjids, even in residential settings, it's going to be a few people, 4 or 5 people again. It may be a bit more, but we can't say because it depends on acoustics, it depends on all these other things. So we've accommodated 20 in the notice of motion because there may be, but it's not going to be more than that. And so they rely on this hadith to say they fall into this category. Now there's some controversy that the amicus raised about this issue as to whether factually my clients fall into this category. It's not for an amicus to raise a dispute of fact. An amicus cannot go around and investigate factual allegations of a party. The state has not raised a dispute of fact, but we've delivered a supplementary affidavit to clarify what we say. And what they say is this. They say they live in their residential area, there is a masjid. It's a few meters away from their house. They can hear the call to prayer without amplification from that particular masjid. They also, in their houses, have a receiver where they can hear the call to prayer at the third applicant's masjid, which is 11 kilometers away. And the adhans go together. So what they say is, because they can hear the adhan from the nearby masjid, this hadith applies to them. They must discharge the duty of going to congregational prayer.